Well, let's get into this real quick. Attorney Walter Hnot, Disability Resolution PA, the most viewed and subscribed to disability attorney in America. Now, there is a tale as old as time. We're not going to be doing that one. We're going to be doing a spicier one. It involves essentially a judge who got in a little bit of trouble, did not tell, the different government agencies who he worked for, and might have been double dipping a little bit here and there, a little bit of double dip here, a little bit of double dip there. All right, so let's get into this real quick. Yes, my glasses are all messed up. That's okay, no worries. All right, let's get into this. This was United States Court of Appeals for the Federal Circuit. Kelly S. Jennings, petitioner versus the Social Security Administration. Okay, let's go through this real quick. I'm not going to read all the attorney stuff, all the yada yada. I'm going to get right down to what happened to this judge so you know exactly what's going on. You can feel the spice coming from these well-dressed judges, these black-robed men and women. Here we go. Petitioner Kelly S. Jennings appeals from the final decision of the Merit Systems Protection Board, sustaining his removal from the Social Security Administration. Just to be clear, he was removed. He no likey, he appeal. All right. Jennings was employed by the Social Security Administration as an administrative law judge, an ALJ, in the agency's Atlanta North Office of Disability Review and Adjudication. Okay, we now call it OHO, Office of Hearing Operations. Okay, Jennings was appointed to his position on July 24th, 1994, pursuant to 5 U.S.C. Section 3105. At the time, Jennings was a commissioned officer in the United States Army Reserve. Okay, so just to be clear, commissioned officer, Army Reserve, also Social Security federal administrative law judge. So this is a highly accomplished, highly intelligent, very capable person. All right. In an order dated December 31st, 2002, the Department of the Army ordered Jennings to report to Fort McPherson, Georgia, for active duty. The order noted that Jennings was being activated for 1 year unless sooner released or unless extended, and expected to report on January 2nd, 2003. Jennings' tour of active duty was subsequently extended through December 31st, 2005 by orders dated December 8th of 2003, February 24th, 2004, and October 27th of 2004. Meanwhile, Jennings continues his employment as a full-time ALJ with the agency. So he was being a judge deciding Social Security cases, but also he was on active duty and he got called up. So yada, yada. Jennings was deployed to Kuwait from April 2003 to July 2003. Upon his return, Jennings was ordered to the Army War College in Harrisburg, Pennsylvania, for 15 days. Jennings requested appropriate leave from the agency and was granted leave for those absences. Similarly, Jennings requested and received leave for temporary duty stations in Florida, Kuwait, and Qatar in 2004 and 2005. Unbeknownst to the agency, the Social Security Administration, when Jennings was not deployed to other locations from January 2003 through December 2005, he remained on active duty at Fort McPherson. Jennings spent nearly every non-deployed day during this period working at Fort McPherson from 6 a.m. until approximately 3 p.m. Jennings then traveled to the agency's Atlanta North office to work up to 6 hours before taking work home with him to complete in the evening and on the weekends. So in other words, he was working a lot. And apparently he was getting it done. You know what I mean? He was just, he took on a lot. He was doing 2 jobs at the same time. This case arises in part because Jennings signed a certification when he started working at the agency, the Social Security Administration, agreeing to work a fixed tour of duty from 8 a.m. to 4:30 p.m. Monday through Friday in the Atlanta North office, aside from 3 months in 2003 when Jennings was permitted to work remotely as part of the agency's Quality Assurance Review Project. Jennings' certification required him to be in attendance at the office during his fixed hours. Specifically, the fixed tour required Jennings to be available in the office for the core hours from 9:30 a.m. until 3 p.m. unless conducting a hearing. Because, if you have a hearing, sometimes it could go later. And what happens with a lot of the judges is they'll usually do 5 hearings in a day. and then basically it runs over. So, they may start at 8:30, but they'll end up somewhere around 4 or something, 5ish something, etc. The undisputed facts demonstrate that Jennings was rarely, if ever, present in the Atlanta North office during the core hours. After reviewing an anonymous report in March 2006 regarding Jennings' failure to work his fixed tour of duty due to his dual employment, somebody reported him, somebody got him, okay? The agency, the Social Security Administration, Office of the Inspector General, OIG, opened an investigation. The OIG completed its investigation in November 2006 and concluded that Jennings simultaneously worked for the agency and the United States Army and received pay from both. Now, I just want to point something out real quick. Couple of quick details. I want to go through those who basically did a donation, and I just want to go through Diana. Princess Diana did a donation for $5, and yes, I saw your call thing, so give me a call tomorrow. Also, My Stanley Cup, thank you for the $1.99 donation. Big thank you there with a big heart. That's absolutely amazing. Excellent. So here's the basic thing, okay? In the government, when you have somebody that's a super hard worker, a super high achiever, a real wowzer, but needs a little bit of customized scheduling to, make it all fit together, the government takes them to court. That's what you should take from this. If you are special, unique, a super hard worker, an achiever of achievers, the government will take you to court. That's what you should get. In the private industry will be like, well, shit. I mean, maybe we could double up on his caseload, pay him a little bit more, and then pull him from the military, put him into, basically the SSA, and have him do twice the cases. You know what I mean? Maybe we can make it work. That's the private industry. But the actual, the non-commercial, the government industry says, how dare you? I shaketh my finger. Nah, you shall be taken to court. All right. Upon receiving the OIG report, Regional Chief Judge Garman, high-up judge, Jennings' second-line supervisor, had his office begin its own investigation. Judge Garman personally interviewed Jennings on April 17th, 2007 at the Atlanta North office. An ALJ Union local area representative, Judge Oslander, was also present for the interview. During an interview lasting approximately 30 minutes, Judge Garman asked Jennings 17 questions off of a prepared form and wrote down the pertinent parts that applied to the questions that I was asking him, end quote. Within a few days of the interview, Judge Garman prepared a formal summary of Jennings' answers. Okay. Now remember, judges usually support judges. What do I mean by that? Judges will usually find a way to back judges. So as a result of that, just to be very fair with this whole situation, usually you will see judges sticking together. Cops stick together, sheriffs stick together, lawyers stick together, accountants stick together, doctors stick together, right? And apparently political ideology groups stick together. We seem to be seeing a lot of people paid to do that nowadays. The bottom line is they tend to stick together. But what the judges have to watch out for is it appearing to be abuse. It appearing to be something like that. Okay. Star Fury, thank you for the $3 donation. Definitely catch up with me when you can. Very, very cool. Thank you. Excellent. And I also love the photos on Facebook. They look amazing, by the way. So super, super cool photos. All right. With that said, Section 7521 provides that an agency ordinarily may not remove or reduce the pay of an administrative law judge without a board hearing and determination that the action is for good cause. Thus, on August 14th, 2007, the agency filed a formal complaint against Jennings with the board seeking his removal. Okay, so basically, Social Security Administration, they filed a formal complaint, went to the board seeking his removal. The agency charged Jennings with, number one, failure to fully disclose his active duty status. Number two, improper dual employment. Number three, lack of candor, telling the truth, disingenuous. Number four, failure to follow the agency's time and attendance procedures. And five, failure to follow the agency's flexi-place procedures. This is probably like you can be here a little bit, you can be there a little bit, blah, blah, blah. All right. Now, just to clarify here, because as we read through this case, I just want everybody to be on board and understand something. What the Social Security Administration is doing is they are recognizing a hero that fights for our nation who also in the next hours after being a hero that fights for our nation on active duty, would then be able to review and adjudicate claims at a very high mental level. And he would be able to do that, spend the extra time on the weekends doing it. He would be able to make it happen. And what do you do to super soldiers who are great for incredible doctorate level adjudications? You file formal complaints against them, because damn it, if we're going to treat our military personnel right, we're going to do it the wrong way. That's what the SSA said. We are going to remove him. How dare us have such a superhuman on our payroll? That is just not going to happen. No, sir. No. We do not want veterans and active war people achieving greatness. No, we don't. That's how ridiculous this is. Like, imagine if you were a CEO and somebody came to you and said, hey, look, Jim over there, Jim is doing this job. And then after that time, he goes and does this job. The CEO's first question is going to be, how's he doing at our job? And they're going to be like, oh, he's doing great. He's getting it done. It's being done correctly. Oh, there was a snitch that snitched on him, but he's doing the job great. The CEO then of the real world would then say, cool, I think we should figure out a way to pay him more and have him do more cases and get him off active duty so we can actually use that ramp up that he's got, that magic. That's how the real world would work. That's how the real world would happen, but not in the federal government, and damn sure not at the Social Security Administration. No, sir. No, sir, we're not doing that here. Harry Bear, thank you for the $9.99 donation. That's awesome. Very, very cool. Put a little heart on that. OTR ineffective. Seems like the hearing is going forward Tuesday. Needs some goods karma here. Absolutely, good sir. Always catch up. Well, it's Tuesday, but always catch up with me if you have any questions. No biggie, no worries there. My Stanley Cup 09, $4.99 donation. Again, thank you. And I don't know if you guys saw, but somebody let the Panthers have a good time and win a very shiny cup. That's the second year in a row, making the Oilers not look so slippery. Now, let's keep rocking and rolling. So basically, we got here, the board assigned Judge Cates of the National Labor Relations Board as the presiding judge. You notice how they got a judge away from the Social Security Administration? They wanted this to stick. They wanted to take that American hero and make sure that he wasn't working at the Social Security Administration. That's what they were doing here. All right. A hearing was held on March 17th and 18th, 2008, after the completion of discovery by both parties. On June 16th, 2008, Judge Cates concluded that the agency established all of the charges by preponderance of the evidence and affirmed the agency's removal of Jennings. On January 6th, 2009, the board denied Jennings' petition for review, and the initial decision of Judge Cates became the final decision of the board. Jennings appealed. So our super soldier that the SSA threw out. Like, you know what I mean? That's like you ever notice, like, when you have like really hardworking super people, they never end up in the government unless they're politicians, in which case they use their talents to mislead people. Have you ever noticed that like the really brilliant people, like, they'll make it to maybe NASA, although NASA's got problems now. NASA's got a problem. Because now space travel, through Elon is profitable. So now NASA has a problem. NASA can't get the brightest people. The people getting the brightest people are basically, Blue Origin, essentially anything Elon touches, and then basically China. They do a good job with snookering the brights. All right, let's get through this. We may set aside a decision of the board only when it, number one, arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with the law. So in other words, it's a shitty decision. Number two, obtained without procedures required by law, rule, or regulation having been followed. It was a kangaroo court style. Number three, unsupported by substantial evidence. They got a fact or a law wrong. All right. We review matters of law without deference and matters of fact to determine if substantial evidence supports the board's finding. All right, here we go. Jennings does not challenge the legal sufficiency of the charge of failure to disclose his active duty status. He says, okay, you got it. You can have that one. I'll take the zing. Instead, he renews on appeal his factual argument made to the board, claiming that he disclosed his active duty status by providing Judge Spivey, the Atlanta North Hearings Office chief judge, with all of his military orders. Jennings argues that the board erred in failing to credit both the documentary and testimonial evidence he provided to demonstrate that the agency was aware of his active duty status. We review the board's factual determination on this issue for substantial evidence. Now, remember, this is like 2006, 2005, 2006, 2007. So, yes, email existed, but no, we weren't sending a lot of stuff through email that was like, let's call it PDFs, Word. We weren't sending a lot of that through email. Okay. At that point, what we were using, we were like after the step of those crappy white laptops with the little ball on the screen on the side of it there. We were, just starting to get things like Alienware computers and blah, 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 and stuff like that. But the point is, he could have, during that time period, just to put it in place, handed this other judge his orders. But then the question becomes, why didn't that judge hand his receptionist or his clerk the orders to then submit it into the online system? But then we get to the point of back then, they didn't have the online system being used as much like we do now. Now the ERE contains lots of stuff. But back then, they didn't have it like that. They were still using giant folders that were in these like giant rounded bottom things. And you put the folder in that with another folder, and the whole thing held it. Remember, when I started to intern, I was interning at a firm that had everything in paper file forms. Okay. Yeah. It sucked. You had to like pull everything, and some of them were ridiculously heavy, and they all had this weird smell to them. I don't know what the deal. Anyways, all right, bottom line. All right, so he says Jennings does not challenge that, but he said he gave Judge Spivey, hearing office chief judge with all of his military orders. So he says, hey, I gave my boss all the military orders. Jennings argues that the board erred in failing to credit both the documentary and testimonial evidence he provided to demonstrate that the agency was aware of his active duty status. We review the board's factual determination on this issue for substantial evidence. So in other words, they're going to go ask Spivey and say, hey, Judge Spivey, hey, Chief Judge Spivey, what happened? Did you get something and not like tell us? Did you whoops? I mean, what happened? Were you sitting there eating a sweet treat and didn't realize you had to put it, in a folder somewhere? Okay, well, that's all right. A careful review of the record supports the board's decision on this charge. Judge Spivey specifically testified that he was not aware that Jennings was on continuous active duty from January 2003 through December 2005. Jennings makes much of the fact that although Judge Spivey could not recall being provided military orders by, it's going to say Jennings, Judge Spivey acknowledges at the hearing that it could have happened. It could have happened. However, this possibility does not counter Judge Spivey's specific testimony that he was not aware that Jennings was reporting daily to Fort McPherson for active duty during the 3 years in question. Furthermore, Jennings admitted on cross-examination that he previously testified at his deposition that he could not recall whether he gave the 2003 orders to Judge Spivey. Not good for Jennings. Jennings also testified that he could not recall if he gave Judge Spivey a copy of his February 23rd, 2004, October 27, 2004 orders. The evidence cited by Jennings to prove he provided his orders to Judge Spivey is contradicted by other evidence and at best inconclusive. So what does this mean? It means Jennings got a problem, and the problem isn't going away. And Jennings, our superhuman active duty soldier, is also an administrative law judge. Now, I just want to point out there, not anybody can become an administrative law judge. You have to have a Juris Doctorate. You have to pass through these exams. You know, if you're military or a minority or whatever, they give you point boosts. But the bottom line is, like, you got to earn your spot. Even if you get extra points, you got to earn your spot, right? They have like these things where you get point boosts and stuff like that. But the bottom line is, which is what it is. If you're military, I don't know if it was military or minority that they give you the biggest point boost. I forget. It might have been equivalent, but I'm not sure. But the bottom line is, he had to become a federal judge, and that ain't a small task. That is not a small task. Had a Juris Doctorate and was a super soldier. I mean, you're gonna fire that guy? You're gonna fire that guy? I mean, no offense, but Social Security Administration, maybe some priority adjustment here would have been, would have been an excellent option. Moreover, the ALJ noted in his decision that Jennings appeared angry at the hearing and seemed to believe that the dual employment and related charges were simple technicalities. He stated that Jennings found it very difficult to give direct responses to questions. He had to caution Jennings not to give non-response and evasive answers. So they got Jennings. Jennings got mad. Now, super soldier pissed, right? As a result, the ALJ concluded that Jennings attempted to mold and shape his testimony to achieve a particular end at the expense of the complete, full truth. He thus did not credit Jennings' testimony and found that Jennings did not fully disclose to the agency his active duty status with the United States Army. So in other words, Jennings was doing two jobs at once. And he may have told, but we don't know, and probably didn't, his supervisor. Our review of the factual determination is limited by statute to assessing whether substantial evidence supports the board's findings. Further, the board's credibility determinations are virtually unreviewable on appeal. Several factors got an administrative law judge in deciding which of conflicting testimony to credit. The ALJ noted in his decision that he carefully observed the demeanor of the witness as they testified and relied on their demeanor in determining the credibility of their respective testimony. The point I want to make with this video is that when you're in front of essentially a judge, you cannot lose your shit unless you are claiming that you are mentally unsound or there was some horrific thing that occurred to you that would make you show that emotion. Otherwise, you have to keep a calm demeanor. You have to play the role of somebody who does not show emotions, does not show this and that. You have to professionally control yourself in front of those judges because those judges will eat you alive. They will eat you alive. I'm telling you, the things that I'm having a hard time remembering his name right now, the crocodile hunter, Steve Irwin, could not catch. That is what will eat you in a hearing. One of those, a scary monster. We will not name it, although we call them judges. They can be very scary, and you've got to keep that demeanor professional. Yes, Your Honor. Understood, Your Honor. I appreciate it, Your Honor. The whole truth is this, Your Honor. Yada, 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 yada. You've got to keep the demeanor locked in. All right, rock and roll. Thus, we must give deference to the ALJ's conclusions that Jennings did not fully disclose his active duty status to the agency as there is no testimony to demonstrate otherwise aside from Jennings' own testimony. So because of his demeanor as a witness, they threw a federal judge under the bus. Now, finally, Jennings points to additional documents that he claims the board ignored. Even ignoring the lack of reliability of these documents, they do not demonstrate that Jennings disclosed his continuous active duty status. Rather, the documents cited by Jennings merely reflect facts already conceded by the agency. It is agreed by the parties that the agency was aware that Jennings was periodically deployed during the period in question and that Jennings took appropriate leave during those deployments. So, I don't know. What do you guys feel? Do you feel that Jennings, who they knew was employed, like they knew he was employed by, the active duty reserve fact, they knew he was employed by them. And they knew that he was taking, basically given an appropriate and allowed breaks. Like, you know what I mean? Like where he was allowed to go someplace. So like they knew that, you know what I mean? They knew what was going on. They understood what was going on. So to my belief, it's just like, he's kind of like throwing his hands up. Like, I told you, you were aware, you knew I was working there. You knew I was doing stuff. You knew I was double dutying. Like, what the hell? It was kind of like one of those situations where they knew, but everybody was just like playing along. And then somebody reported him to give him shit. And that ruined his life, right? Because now he's got a board thing and now he can't be a super soldier because America doesn't love him anymore. Remember the lessons from Captain America. You're only the hero if American politicians deem you to be so. Princess Diana, thank you for the $5 donation. Absolutely love it. That's very, very cool. Also, happy birthday. Very, very cool. Excellent. Very good. All right. So also, please remember to hit the like button and please remember to subscribe if you like these videos. Also, I am going to be going live after this video to answer questions for free about disability law because we didn't do one on Monday like we were supposed to. And I can't remember if we did one on Tuesday. I think we might have, but I'm not sure. Doesn't matter. We're still going to do it. All right. Now, on the second charge of improper dual employment, Jennings does not dispute the evident fact that he was working a full-time ALJ job while on active duty in the Army and engaged in dual employment. Instead, Jennings' arguments on appeal target the agency's position that his dual employment was improper. Jennings correctly points out that the agency fails to cite a statute or regulation directly on point that prohibits full-time agency employment while serving in active military duty. Because, you got to understand, these federal jobs, they don't pay shit. You know what I mean? Like, federal military service doesn't pay well. ALJ, I mean, it pays okay. I mean, it pays pretty good. It pays better than a lot of jobs. Well, let me ask you guys this. Do you think administrative law judges should make, starting out, around $130,000 to $140,000, and then once they've been there 6-7 years, making $185,000 to $190,000? Do you think that is an appropriate amount that they should be making? Do you feel, realistically, at the end of the day, that the Social Security administrative law judges are getting a fair fee to do their job? I don't think federal judges should be making under $200,000, because the problem is you want judges to financially have enough money to never be in a situation where they have to feel like they have to do more. And I feel like if a judge is starting at 135, 140K, that is not acceptable, because that judge is going to be tempted by things that, essentially require additional funds. So I just don't think that's enough. As Charlton Zimmerman said, $7.25 per hour. That's it. $7.25 per hour. Done. Charlton Zimmerman does not believe our judicial system deserves a good pay. He believes they should earn our base pay, which is, hey, you know what I mean? That Juris Doctorate. Who's going to pay for that JD? Who's going to pay for that academia? Star Fury, $5 donation. The military and Social Security Administration should be separate, period, in everything, including benefits. Yeah, I agree. Because at the end of the day, you want to have a military benefit separate and stackable with the private, with the civilian benefit, of course, SSDI benefits or retirement benefits. So I agree, because once you start to intermingle those two benefits, they'll start like not allowing you to stack them, and this one reduces that one and all that shit. Yeah, we don't want that. We want you serve in the military, you get to stack that benefit. All right, so here's the bottom line. Jennings correctly points out that the agency fails to cite a statute or regulation directly on point that prohibits full-time agency employment while serving on active military duty, with no statutory target prohibiting dual employment to shoot at. Jennings instead carefully distinguishes each dual compensation statute from a situation. The agency concedes that there's no statutory bar to Jennings' dual employment, but responds that the record contains unrebutted testimony showing an agency policy that prohibits such dual employment. In other words, there's no statute, but it's the policy of the SSA that prohibits dual employment. But again, that's kind of my point. Like, why do you think he was doing these two jobs? He wasn't spending his weekends doing this because he just loved being a judge. And I know some of you were like, he must love it deep in his bosom. He must be bosom deep. No. That's not what happened here. He wanted the money. Okay. He wanted the money. That's what happened here. At the administrative hearing, a veteran agency human resource specialist testified that the agency's policy prohibiting dual active military and full-time civilian employment is based on decisions of the Comptroller General of the United States and on guidance provided by the Office of Personnel Management, OPM. Our review of these decisions and OPM's public notifications support this testimony and demonstrates that there is a basis for the agency's conclusion that such dual employment is improper. I just want to point out again that a super soldier that was also a judge literally got snarked on by some snitty person who then got him basically before a board to remove his achievements as being glorious. That's why it's a little rough. Like when people are like, Walter, you should have gone into the military. And I would have preferred to. The benefits are amazing thereafter. But the problem is it's political. The higher up you get, the more political it is. It's not about serving the nation. It's about serving the politician. And that's what you run into. It is clear from the record that Jennings was not able to satisfy his agency fixed tour of duty while simultaneously serving on active duty at Fort McPherson, which is basically he just had to be at different places at different times. Like if it were a company, like a private company, they would have been like, cool, you want to work later? We'll set you up to work later. You're doing the work? Cool. We'll set you up. We'll have you doing hearings, extra hearings over the weekend. We'll punish you with some more. That's how it would go. The agency made clear that it was based its charge on long-standing agency policy and not on statutory regulatory support. So Jennings' attempts to attack the agency's position based upon non-applicable statutes relating to dual compensation, not dual employment, missed the mark. We therefore affirm the board's decision that Jennings engaged in improper dual employment. Bottom line is the remaining charges, they get kicked around. But this is my point. The federal government has a tendency to destroy talent. Talent is usually restricted so heavily by procedures and this and that they usually work for the government for a little bit and then they get the hell out and they go start their own company. That's what happens with a lot of these individuals. Do you feel that the Social Security Administration, who brought him up on charges before the board, was correct in getting rid of this super soldier from basically being an administrative law judge and working the weekends while also being on active duty? Now, a point that I want to make here, and I think it's pretty darn important, but a point I want to make. If he was on active duty and there was a really big problem, well, then there's a problem because he would have to devote more time to being on active duty as opposed to giving the time to the SSA. So you have a crunch situation. If the SSA needed him to take more cases or his active duty status became more aggressive, the bottom line is, just to be fair with this situation, he would need to figure it out. And he was running out of time because he was already using his weekends to go ahead and do the Social Security Administration administrative law judge job. So my point to you is this. At the end of the day, do you feel we should kick super soldiers out of the way? Or do you feel that we should make room for them to achieve the most that they can? Attorney Walter Hnot, Disability Resolution PA. Hope all is well. I'm going to be doing the next video where I go live for free to answer questions. You know how it works. 5-minute consultations, no story mode, no question stacking. Have your legal question ready. Use a fake name when you call in, and we will rock and roll from there. Please remember to like, subscribe, head over to Google, type in Disability Resolution Law Firm or Disability Resolution Florida. Throw some stars up there if you like. You can also go ahead and basically put some positive vibes in there for me. With that said, I will go live after this video. And if you need more than 5-minute consultation, in the bio area below, there's a mini contract for a full 1 hour. We usually do about hour 10, hour and 15. I see YYZZ. Mahalo. There you go. Howdy, howdy. Let me put a little heart on there. That's awesome. You guys have an amazing, amazing night, and I will see you at the next video shortly. I have to create the thumbnail, and we will rock and roll from there. I see Leanne. I see one. I see Princess Diana, Lisa Boston, Kayla McComber, Marty the Alien, Linda Soda, James, M&M Motives, Leanne, again, howdy, howdy. Good to see you all. I will catch you in the next video shortly. Give me about 10, 15 minutes, and we'll rock and roll. Thank you so much. Bye-bye, everybody. Bye-bye.